Welcome to Bottom Up, a monthly podcast dedicated to issues and topics of interest to young lawyers in Wisconsin and beyond. I'm Emil Oviagele.
And I'm Kristen Hardy, and we're your hosts. This is the Bottom Up Podcast.
Hey, Samantha.
Hey, Joe.
How you doing?
I'm doing great. How are you?
I'm doing great. Man, it's already August.
I know.
Where did the summer go?
It's a great question.
What have you been doing this summer?
Oh, well, we've been very, very busy at the Wisconsin State Bar. There's been a lot of activities. There's been a lot of new developments. One of the biggest developments that we're very excited about is actually coming this fall, the end of summer, and it is a brand new Tort Law book by Blocher.
Oh, Blocher. Okay. Mm-hmm. Now, we should probably tell people who you are, all right? This is, I'm Joe Forward. I'm the communications director for the State Bar of Wisconsin. We're back at the Bottom Up podcast. We're sitting in for Emil Oviagele and Kristen Hardy today. Samantha has been so kind to say yes when I asked her this morning to come on. Samantha, tell the folks who are listening who you are.
Sure. My name is Samantha Cherney, and I am the product development manager specifically with books for the Wisconsin State Bar. So I work with the team of attorney editors that work with our attorney authors to create all of the legal books that are available to Wisconsin attorneys.
Okay. Now, you mentioned the new book, the new torts book, and you mentioned the author, Blocher. I'm really pleased to say that Blocher is here today with us. Oh my God, Jesse.
Hi, Jesse.
Blocher, he's a partner at Habush Rottier. He is an author, a Pinnacle Books author of a new torts book that is coming out this fall, as Samantha mentioned. He is also an award-winning writer for Wisconsin Lawyer magazine. I think it was not this year, but last year, Jesse won the Charles Dunn Award, which is given to the author of the best article of the year. So Jesse won that award last year. We were really pleased to have him submit that article. It was called the Pugilist's Guide to Legal Writing, legal brief writing, right?
Right.
Okay.
Yep.
Jesse, welcome. Thanks so much for being here today.
Oh, thank you guys. Thanks for having me on. Appreciate it.
So we mentioned the book. We mentioned that you write a lot. You've submitted several articles for the magazine over the years. So I want to talk about why you write and the benefits of writing and, what it does for your career. But first, I want to get a little background. So tell the listeners how you got into law, what you do. And, obviously a lot of our listeners are young lawyers, so we'll focus on some of the things that you did early in your career to get career moving and to advance in your practice area. So tell us a little bit about how you got into the law.
Sure. Well, I think I was one of those weird people that always wanted to be a lawyer. I didn't really know what to do in college to get there. I settled on a business major. I went to Madison for college, and growing up, I had an uncle that was a lawyer who I really looked up to, and I liked legal shows like Law and Order. But funny enough, through my business background in college, I thought, well, maybe I'll be a corporate lawyer. And so then I went to Marquette for law school, and in my first year, I had a summer internship, which is sort of rare, but it was at an insurance defense firm. And for those that are not in the personal injury world like I am, what that means is it's a defense firm that defends insurance companies, doctors, small businesses in lawsuits, mostly personal injury lawsuits, but some other kinds as well. And so I started there as a clerk, and I really enjoyed it. I felt like I had an aptitude for it, and I still sort of thought in my mind that I would want to be a corporate lawyer, and I applied to some of the bigger firms, and I didn't get the opportunities that I wanted. And I think in hindsight, that was probably right. I just don't think that they were the right fit for me or I was the right fit for them. But so I continued working at this insurance defense firm through law school. And, by the end of law school, I was, doing associate type work, legal writing and briefs and things like that. And then I took a job at a different insurance defense firm out of law school. And I did that because I thought that firm was going to be good about getting their associates deposition experience and trial experience and motions and appeals and those kinds of things. I just thought, that's a really good, starting place. I did, when I was in law school, I edited this journal called the Federation of Defense Counsel Quarterly. And Rick Gass, who's now passed, was the practitioner editor of the publication. I had lunch with him during law school, and he said, treat your first 4 years like an internship. Don't worry about what your salary is, just worry about what experience you're getting. And so the job that I got out of law school, I felt like was a really good one for experience, and I did. It worked out that way. There were great people, there were great mentoring there. I really enjoyed my time there. And I had, I think, 12 trials in the first 4 years.
Wow.
And a whole bunch of depositions. And I got to meet and network with a lot of other lawyers in the litigation community and do some brief writing and some appellate writing. So that was a really, really great experience. And then about 4 years in, I was thinking about, okay, I think I would be on track to make partner here probably. But do I want to stay here, or do I want to kind of dip my toe in the water elsewhere and see if there's something else? And I always had in the back of my mind that I wanted to represent plaintiffs. I really enjoyed where I was working at first. I enjoyed the people, but I thought that I would enjoy representing individuals more than insurance companies. And so some people have the opposite bias. But anyway, so I put some feelers out, and one day Bob Habush called me, and I didn't really know him. And he had me in for an interview, and he and our current president, Tim Trechik, were there, and our managing partner in Milwaukee, Larry Faring, were there, and sat me down, and we had a nice long chat, and he said something like, I think I like you. And I said, shaking, I like you too, sir. And then he hired me right there, and that was 15 years ago. So yeah, it was a great opportunity. At the time, Bob Habush has since retired, but I think most people in the legal community know about his accomplishments over time. Some of the most famous, newsworthy personal injury cases in Wisconsin history, the Miller Park case.
Yeah.
And so a lot of people, including me, wanted to work and learn from him. And I didn't get to work for him directly a ton before he retired, but working at this firm has been a, fantastic experience. And I do enjoy, for a lot of reasons, representing individuals in personal injury lawsuits. And so that's kind of how it started and how I got to where I am.
When I was working for the state bar early on, I interviewed Bob Habush because he had won some award, and I was so nervous to interview him. And the only other time I was more nervous was when I interviewed Barry Alvarez. So, because, he just has that, something about him where you just don't want to make any mistakes around Bob Habush. But anyway, that's a great story of how you kind of started out. Tell me a little bit about those early years practicing here as a plaintiff's attorney, and some of the challenges or opportunities that you had when you first started here.
Yeah, our firm, I think now we have, it's 33 lawyers. We've oscillated between 32 and maybe 36 over my time here, but it really runs like a collection of small firms because we have 13 offices, and so we're kind of spread out all over the state. And there's tremendous opportunities here, I think, for mentoring. The people are wonderful, and I've had great opportunities over time to demonstrate my ability and aptitude and willingness, and also then get into more significant cases. And a lot of what I do right now is products liability cases, which I know we're going to talk about. But I think really, when you're an associate and you're trying to work your way up, the key is to, in some ways, ingratiate yourself with the people that you're working for. And so one of those things, which I know we're also going to talk a little bit about, is legal writing and doing that well. So I always, from the beginning, took a lot of pride in that. I felt like it was something I was, kind of good at from the beginning. But it's really just sort of simple things. It's, it's understanding the record. It's working hard to, know the details of the case, the depositions, what's gone on before, the pleadings, the issues that have come up that you're now having to write a brief about. And then, competent, thorough, tenacious legal research and coming up with the right arguments in a simple structure. There was an article that I wrote for the State Bar about, brief writing. You mentioned it before, but it's sort of just really a list of simple guidelines you can follow to write a competent brief. And I was lucky to have some of that advice early in my career. And so when you write briefs on someone else's case, that's a good way to show that person that you work for, that you've taken the time to do it well. You've taken something off of their plate that's very time consuming and perhaps they didn't want to do. And that you know the record, you've analyzed the record, you understand it, you understand what the right arguments are. And I think that for associates in litigation work, brief writing is really I think the number one way that younger lawyers can show the partners that they're willing and eager and intelligent and have some talent for the job. And that, at least for me, was sort of the way that I moved up early in my career and then was given opportunities based on that to take depositions and to get into trial. And, but really it's those, it's being reliable, being where you say you're going to be at the time you say you're going to be there. It's getting your assignments done in a reliable fashion. It's sometimes asking the right questions. It's, having a positive, eager attitude. And then, not all opportunities are just handed to you. Sometimes you need to volunteer to do extra work, especially in the beginning of your career. And, when the door opens, step through it. Sometimes it's asking a question, of someone that does something that you want to learn from. Is there anything I can do on any of these larger cases that are coming up? And that's a good way to allow yourself to tag along for trial. There's not a lot of trials these days. It seems like they're getting less and less. Hopefully we've kind of plateaued with that, but they're getting less and less over the years. And so the opportunities for young lawyers to get into trial, early in their career, a lot of times they're going to be as a second chair. And that's great. And you can learn a lot from that, but you have to make yourself valuable to the person that's the first chair, and be known to them. And so, I think those things, a good attitude, being reliable, being eager and willing, especially early in your career, that can pay dividends.
And now, a word from our sponsors. Who better to trust when you're facing a malpractice claim than Wilmick? With their Wisconsin licensed claims attorneys and strong network of defense counsel, Wilmick was created in 1986 by Wisconsin lawyers for Wisconsin lawyers, and they continue to demonstrate their commitment to Wisconsin's legal community. Find peace of mind with Wilmick.
Are you tired of figuring it out alone? Join Wisconsin's top solo and small firm lawyers October 16th through the 18th at the Kalahari Resort in Wisconsin Dells for the 2025 Wisconsin Solo and Small Firm Conference. Connect with your peers, learn real strategies you can use immediately, and leave ready to grow your practice. Register today at wssfc.org.
Suing over a defective product or defending one? Either way, you need Wisconsin Tort Law Products Liability in your corner. It's packed with case law and clear guidance that gets you courtroom ready fast. Don't wait. Order yours today at wisbar.org/books. Thank you. And now back to the Bottom Up Podcast.
You mentioned there's not a lot of trials, and I have seen that over the years. I've written a couple articles about the disappearing jury trial, and I think I was looking at some of the stats from the court's website, and it's like less than 1% of cases or something like that. Does it sound right to you?
Yeah, we sometimes have looked at those same statistics. I wrote an article about, I think it was an Inside Track blog about mediation not too long ago, and I think there's several factors that go into that. One is mandatory mediation. I don't know, it was before my time, but what decade exactly judges started ordering that. But every injury case now you have, or almost every injury case, you have mandatory mediation. So the parties go sit down in a conference room or over Zoom with a neutral lawyer who's very experienced, and he goes back and forth between them and tries to settle the case. And oftentimes, even if it doesn't settle there, that makes some progress, and then the parties settle it before the trial. And the reason for that is because I think there's a more informed discussion, and perhaps the parties getting outside of their, I don't know if comfort zone is the right word, but thinking about the other side, thinking about it from the perspective of the other side a little more, and the client and the risk. And then another factor I think is cost. It used to not be quite as costly to try these cases. And so, when clients are evaluating, in our world, in the personal injury world, we're trying to figure out, what is the best way to get the client the best recovery if you're representing a plaintiff? And if you're representing the insurance company on the other side, it's what is the best way to resolve this case in the most cost-effective way to the insurer? And so the fact that the parties are spending so much money in costs now on the trial itself, we're thinking about the net result to the client. And so especially in medium and smaller size cases, sometimes it can be difficult for the client to be in a situation where they're going to do substantially better by trying the case versus the offer that they're being given. And the insurance company, the same thing. The insurance companies generally pay their lawyers by the hour. And the biggest expense is experts. Every personal injury case, at least the plaintiff has medical experts, and most of them are all institutionalized within the hospital system now, and they charge a significant amount of money, as maybe they should, to step away from their practice and come and give testimony at trial or on a video for trial. And the defense experts have similar arrangements. And then depending on the complexity of the case, there might be engineers or other things, and that, is a five-figure outlay for sure, and sometimes much more than that if the case is not so simple.
Yeah.
So I think those two things probably are the most responsible. As mediation gets the parties talking, where maybe there was some, I'm only speculating before my time, but maybe there was more ego involved with the lawyers battling before. Mm-hmm. And you can get kind of dug into your position. And so the mediation, whether you would argue that's helpful or harmful, sometimes gets you out of that and gets you thinking a little more about the risk and the other side's position. At least it gets the client thinking that way. And so I think those two things are probably primarily responsible for trials being less and less and less over the years.
Right. Let's talk a little bit about products liability area and the book that you've been writing.
Sure.
So do you do a lot of products liability first, and then did you see a need was there a gap in the information that was out there about that specific practice area that prompted you to want to write a book about it?
Yes.
Okay.
I think the answer to the last question first, yes. I think from what we had looked at, the State Bar's Brown Book series, which is fantastic. I still call it the Brown Book
series.
What is
a
it
lot of
called
people
now?
do, yes.
Everybody does.
Okay. The Books Unbound, if you get it online. But there weren't any tort books. And so this one is the first in a planned series of 3. Mm-hmm. I'm not writing the other 2.
Okay.
I'm just writing
All
this
right.
one.
That's one's probably good.
There are others that we have on board to write the other 2. But the first book is Products Liability Law, and then the second book is going to be more focused on sort of general negligence law that I would say makes up the bulk of personal injury cases. And then the third book will be medical malpractice and maybe also nursing home type cases.
Okay.
And so my practice has sort of evolved over the years. When I was a defense lawyer, the first 4 years in my career, I did a little bit of products liability work before leaving, mostly as an associate helping because these cases tend to be bigger and much more involved. And then coming here, when I started here, it was almost all sort of run-of-the-mill personal injury cases, auto accidents and mostly. Mm-hmm. And then starting out as kind of associate work and transitioning into, one of the lawyers that generally here handles the products liability cases has happened sort of over the last 10 years, I would say. And now I think in terms of my time, probably is more than 50% of my time that's dedicated to the products liability cases. But we can talk about this a little more too. The cases are much more involved. There's the significant factual detail. There's some legal complexity, and then there's a lot of engineering and cost and things like that go into them. So usually on any products liability case our firm handles, we'll almost always have 3 lawyers working on them. And we have a group of lawyers that do the products liability cases. So Tim Trechik, our president, he leads it. And then Rob Jaskalski, myself, Peter Young, who's in Wausau, and Alyssa Bolin are generally involved. And then Susan Tyndall also helps us with brief writing and things like that, as do I. But so generally speaking, there's a lot of support, and then there's a lot of staff support on these cases. And we can run through that if you want. But you asked about the book.
Yeah.
And so there isn't a State Bar book on tort law. And so we divided it up into these 3 areas that we think would be helpful to people and that make up sort of the most common varieties of tort cases that Wisconsin practitioners would handle. And then I don't know that there's really another comprehensive research on tort law, especially products liability law, that's Wisconsin specific. So you can go to the jury instructions. There's some stuff in the Wisconsin practice series, but the idea with this book was to be a comprehensive resource on products liability law. It's not intended to be a practical aid, really. Sometimes the structure of the law can help with that.
Yeah.
But really, it's supposed to be a comprehensive resource on the law, the legal standard. There's some complexity to it, as I mentioned, and then a lot of the issues that practitioners might face in, motion practice and discovery. And these cases often get removed to federal court because there's an out-of-state defendant, and so you have plaintiff in-state and defendant out-of-state, so those cases can be removed to federal court. So there's some discussion of state law procedure, there's some discussion of federal procedure, there's some discussion about verdict formulation, although that's a difficult task in a products case. There's not a ton of guidance in the authority for that. Mm-hmm. So we think we hope that the book helps the state bar out and that it's a good resource for those that are practicing in this area.
Yeah, that's great.
We think it fills a hole within the portfolio too. There's definitely a spot for it.
Yeah.
Excited.
So in that, we're thinking this fall.
Yes. Okay. So the release date is August 29th, to be specific.
Okay.
August 29th, 2025.
It's done. I'm done with it.
Oh, you're done. Okay.
I'm
this
done
is a relief.
for sure.
And then when will the other two come out?
We're planning on a successive series every fall, so look for the next book on negligence next fall, 2026, and then the third and final of this part of the series in fall of 2027.
Okay.
And now, a word from our sponsors.
Are you tired of figuring it out alone? Join Wisconsin's top solo and small firm lawyers October 16th through the 18th at the Kalahari Resort in Wisconsin Dells for the 2025 Wisconsin Solo and Small Firm Conference. Connect with your peers, learn real strategies you can use immediately, and leave ready to grow your practice. Register today at wssfc.org.
Who better to trust when you're facing a malpractice claim than Wilmick? With their Wisconsin licensed claims attorneys and strong network of defense counsel, Wilmick was created in 1986 by Wisconsin lawyers for Wisconsin lawyers, and they continue to demonstrate their commitment to Wisconsin's legal community. Find peace of mind with Wilmick. Thank you. And now back to the Bottom Up Podcast.
And then just a procedural question, Samantha. When someone writes for Pinnacle, for the Brown Books series, all the books, what kind of support do they get? I mean, do we have attorney editors, right?
Yes. Yeah, so they receive the full support of the State Bar of Wisconsin. There are 6 attorney editors on staff, and then we also have production coordinators as well that take the book from manuscript to actual book that you see online at wisbar.org. And Jesse, who can probably attest to this, we work very closely between the attorney editors, me, there's a couple other people on our team to make sure that we're crafting and curating the best possible product for the members. So there's checking in and there's a lot of back and forth sometimes, but I think at the end, it does all come together to create a substantive resource for the 25,000 practicing Wisconsin attorneys.
Yeah, I comment on that a little bit too. I mean, it sort of goes in phases. So there was an outline phase. There were some topics that the State Bar came up with that they thought would be helpful to include in the book, and then a more detailed outline that we wrote. And then there's a drafting phase and some discussion during that phase. And then when we turned the drafts into the State Bar had excellent editors, to make us look good and to go through it and point out some things, both looking at the research to make sure it's good law, correcting citation errors, grammar, some reasoning type stuff, is this really what this case stands for, et cetera. And so we had some back and forth with that, but it was all, appropriate and helpful, and that process wasn't arduous. I enjoyed it, and I enjoyed working with the folks from the State Bar to get it from, a good draft to what I hope and feel is a very good and comprehensive, final resource for people. We'll see what people say when if anybody can stand the boredom of reading the whole thing.
Well, it sounds like some people already like it, Jesse.
Right. Well, and I want to get to a little bit more about why you would want to write a book. And you were really the sole author on this, right?
Yeah, I mean, I had a lot of help.
Okay.
So Dan Rottier, who unfortunately passed in January, was the president of our firm. Tim Trechik is currently the president. They both read the drafts and helped substantially. Our newest associate, Ashley Scott, who's fantastic, she helped with some of the research. And then a number of my other partners helped with a little commentary and ideas, Rob Jaskolski and Susan Tyndall and Peter Young, and I'm sure there were others. So I am the sole author on the book, and I did do most of the work doing the actual writing, but I had a lot of help.
Yeah.
You know, and the state bar as well.
Right. And so, I mean, I'm sure that was a big undertaking for you. Like, it takes a lot of time to write a book like that. So,
Yes.
First of all, how did you do that when you have a regular practice going? And then why did you think that there was a need for that? And why did you raise your hand to be the one to do that?
A number of reasons. I start with the first question first. So how did I do it? I mean, it was extra work.
Yeah.
But in plaintiff's practice, we're generally working on contingent fees. And so the busyness of the practice can kind of ebb and flow depending on where the case is at, especially when we're handling products liability cases, because they tend to get really, really involved where you're working all the time for a couple months or a few months in a row, and then there's a little ebb to the flow, and then you have a little more time. And so it worked out that writing it mostly last fall and early this winter was in a good time in my schedule where I could kind of manage it so I could dedicate a fair amount of time to it. My wife wasn't super happy with me during that period, but I wanted to get it done, and I wanted to have it finished, and so we just dedicated the time that was necessary to do it. Why did I do it? Well, one is I do like to help out the state bar. You know, I've been on the board of governors. I've done, I chair the bench bar committee, and so I like the state bar. Mm-hmm. I think it's important that we share with our members, what it is that the bar does and can help with, one, and two, that it really is a great resource. And where else do you go for, a comprehensive look at, a certain area of Wisconsin law? So that to me was a motivating factor. Our firm wanted to do it because we have some expertise in this area, and it sort of turns out I'm the guy with his hand up a lot of the time, and that I do a lot of brief writing and appellate work and stuff like that, especially on our products cases and other things. I chair the Wisconsin Association for Justice Amicus Committee, so I write a fair amount of appellate briefs on issues that affect the plaintiff's bar. And so this is sort of up my alley, I guess you might say.
Yeah.
And then in doing these products cases for the last decade or so, we've built up a pretty comprehensive bank of briefing on various issues. And so a lot of it's not that anything was cut and pasted from a brief, but we had looked at these issues before.
Right.
So I guess one reason was it's helpful to the state bar. Another reason is that, I think about my career, we like to think especially like now I'm in the middle of my career, like we've gained some status. I own something in this career. I'm a shareholder in a law firm. I have a position that's, we do work of consequence. We have clients, we're responsible for things. You like to think of yourself as having some ownership over it. But when I step back and really think about it, we're really occupying a role, and there's going to be someone else that fills that role, or to the extent the practice changes, fills a similar role in the future. And, the legal field started as an apprenticeship type work, and that's really sort of what it still is, especially in litigation. I don't know about other areas as well, but in litigation, there are skills that you have to learn and you don't get taught in law school. And so it's a pass it down kind of a learning experience. And I think that being a lawyer it's a lifetime of learning. That's what you're committing to. And so I like to think that at the end of my career that I will have passed something on to the people that come after. And so doing these kinds of projects is a good way to do that, I feel. So that's the second reason. And then the third reason is it was sort of daunting to think about at the beginning, but it was a very helpful exercise for us because I tried to cast as broad a net as I could over all of the various issues that come up in these products liability cases and cover them, at least what does the law say, in this book. And I think it helps me in my practice and our products group in the future because it's a good resource for us to fall back on. And it's good for me, just a good refresher on some of this stuff. The law in Wisconsin changed substantially in 2011. And so it was good to review what came before that, what changed and what remains after that, and then to sort of go through all these cases over the last 10 years and see, what the issues were and think about what issues didn't come up but came up in other cases. Just that kind of comprehensive review was helpful to me in my practice.
And now, a word from our sponsors. Who better to trust when you're facing a malpractice claim than WILMIC? With their Wisconsin licensed claims attorneys and strong network of defense counsel, WILMIC was created in 1986 by Wisconsin lawyers for Wisconsin lawyers, and they continue to demonstrate their commitment to Wisconsin's legal community. Find peace of mind with WILMIC.
Are you tired of figuring it out alone? Join Wisconsin's top solo and small firm lawyers October 16th through the 18th at the Kalahari Resort in Wisconsin Dells for the 2025 Wisconsin Solo and Small Firm Conference. Connect with your peers, learn real strategies you can use immediately, and leave ready to grow your practice. Register today at wssfc.org.
In these uncertain economic times, the State Bar of Wisconsin wants to make sure that you and your practice have the best available tools. Ultimate Pass and Books Unbound are available for purchase using 6-month installment plans. Contact our customer service team at 1-800-728-7788 for more information. Thank you, and now back to the Bottom Up Podcast.
What was the big change in 2011?
So in 2011, the Wisconsin legislature passed a strict products liability statute.
Okay.
And so it changed the standard for products liability cases in Wisconsin. There's a case in, I forget which year it is. I argued on behalf of Wisconsin Association for Justice at the Supreme Court. I think it was in 2023. It's called Murphy versus Columbus McKinnon.
Okay.
And that case really sets forth, because there's some ambiguity in really how did the statute change the standard. And so that case sets forth, what changed and what remained. And the idea, I would say it's the statute, the idea was that it's a little bit more of a pro-manufacturer standard than we had in the existing common law. Essentially, before we had something called the Restatement 2 standard, which the predominant type of products liability case is a design defect case. So you've designed this product incorrectly, and I'm injured because of that bad design. In the personal injury world, at least, that's what the claim is. And so prior to 2011, the standard was the consumer contemplation test. And the product is defective if it would not be in the condition that an ordinary consumer would expect, essentially. There's more to it than that.
Yeah.
But that's the gist of it. And in 2011, they changed that to say the product is defective if it's unsafe and unreasonably dangerous and there's a reasonable alternative design. That's not the exact wording of the statute. I could pull it up.
Yeah.
Essentially, it added a reasonable alternative design element and a foreseeability element to the analysis. And so now, if you're trying to say this product is defective, you have to be able to say, okay, but it should have been designed in this fashion instead. And that wasn't a requirement before. You could say the product is defective without a reasonable alternative design. I mean, I think practically in these cases, it's very helpful, and you might be in a little trouble if you didn't have a reasonable alternative design. But some of what was in the prior law, other than that one element, was preserved. The statute added some new defenses for manufacturers, and then the statute preserves the plaintiff's right to a negligence claim. So in products liability world, you have two separate theories. You can pursue both at the same time. One is a strict liability theory, meaning whether or not the manufacturer was negligent, they can be held liable if their design was defective. And then negligence is the failure to act with ordinary care. So if you can prove that they did something wrong in, let's say, the design process or the manufacturing process, that they didn't exercise ordinary care in testing or designing or manufacturing or warning consumers, then you can prove a negligence case. So often in products liability cases, if you go all the way through with trial, you have a verdict that includes both theories. So negligence didn't change, the strict liability standard did.
Okay. What is a typical case that you see? Like, is there a certain industry that, give me an example of a case that...
Well, we tried, Tim Trechik and Alyssa Bolin and I tried a case against Hyundai in 2020, and some of it was newsworthy. There might have been a State Bar article about it. And that case is what's called a crashworthiness case. So we're suing an auto manufacturer, our client is suing an auto manufacturer for a defect in the car. So there's a crash, and then the car fails in an unexpected way as a result of the crash. So in that case, the plaintiff was a driver of a vehicle that was rear-ended, and as a result of the forces of the crash, his headrest posts in his seat deformed towards him and caused him a really significant, horrible, catastrophic injury. And the mechanism to protect you when you're in a rear-end crash in the vehicle is your seat back. You know, seatbelt protects you in a forward collision.
Yeah.
Your seat back protects you in a rear collision. So the theory against the manufacturer was that the seat was defectively designed and it shouldn't behave that way in this rear-end crash. And of course, the manufacturer had a different perspective. The jury agreed with us in that particular case, but crashworthiness cases are what those are called. So the plaintiff may have had a minor injury in that accident, but the terrible catastrophic injury was because the vehicle didn't perform as it should have as a result of the crash. You know, there are other examples from the case law would be farm implements. This used to happen more than it does now. Industrial equipment, workers, blue collar workers, getting appendages stuck in industrial equipment or losing an eye or badly injured as a result of an industrial accident. Sometimes the manufacturer of that equipment has done something wrong in the design, which either makes the accident worse or causes the accident that injured the person. So those are really the predominant type of cases. I mean, there's household appliances, there's fire cases, there's explosion cases, there's chemical cases. There was a famous appellate case about latex gloves that they were designed with chemically not designed appropriately, so that folks with latex allergies had terrible reactions to them. So essentially a product that's improperly designed or manufactured or warned about that injures someone. That's the gist of what products liability, at least in the personal injury world, is about.
So in the book, do you talk about a lot of these cases that have come up in the...
Yeah. So we try in the book, I think I've at least mentioned all of the published Wisconsin appellate cases and many of the published, or they don't call it published, but many of the federal precedents, especially Seventh Circuit, related to Wisconsin products liability law. And it's not just case by case, it's topical, but I think across the book, all of them, or the vast majority, should be in there somewhere.
So we've worked together pretty closely now, and you've worked with my team. And I think what we would like to know is, other than working with the product development team at the State Bar of Wisconsin, what was your favorite part about writing this book?
Being done.
Fair enough.
No, not really. It really probably was working with the product team at the State Bar. I mean, I was impressed with the level of detail they went into. And it wasn't too frustrating.
Good. Good.
The suggestions were almost always good, or at least well thought out. And they really did a thorough job of going over it. I don't know. It's like any writing project. I think it's a grind as you're doing it. Products liability cases especially, the briefing is it's borderline insane. I mean, I think the judges don't like it at all, and I feel bad for them. And we try not to be the proponent of that, but I had one in this spring that, summary judgment and Daubert and motions in limine. Daubert meaning trying to exclude experts. Those are the three main areas that get briefed, and I think that they filed their materials, my responses to the various briefs, trying to exclude the experts and moving to bar certain things in summary judgment was in the range of 170 pages.
Oh my gosh.
And so it's a massive undertaking, and it's a real grind to get through that. And of course, we have lots of resources here and people to help and things like that. But really at the end of the day, like that case, for example, that was on my plate of responsibility. And sometimes it's exhausting to get through it, but good planning, structure, and then when it's done, that's very satisfying, and you feel like it's good, and you get to that stage where it's kind of written, and now you've got momentum, and you're finishing it. You're feeling like it's pretty good. You're making little improvements and things, and that's the stage that I like to get to. So when that started happening with this book, that was satisfying.
Yeah.
It's a huge accomplishment.
Yes.
Oh, thank you.
And you did a great job.
You mentioned that your wife wasn't too pleased, but I want to know, did you go home one night and be like, yeah, I think I'm going to write a book on products liability, and it's probably going to take me a year, and it's probably it's going to take a lot of time. How did you approach that?
Well, I really wrote it in 3.5 months.
Yeah.
So I really crammed it into a short period of time.
We don't usually have those high of expectations for our attorney authors.
So the office here tends to be very busy, and there's a lot going on, and there's people coming into my office and a lot of phone calls and things. So when I was writing the book, I took some extra time at home. So my wife, on the weekends, maybe when we were supposed to be doing something together with our daughter or having plans, I was sitting a lot at my kitchen table or my dining room table and, slogging through it.
Yeah.
And sometimes a little frustrated and a little stressed. And so that part she didn't love. But I think it was probably better that it didn't take a year. Mm-hmm. We just pulled off the Band-Aid and got it done.
Yeah.
There you go.
But she was, as always, very understanding and supportive.
And now, a word from our sponsors.
Are you tired of figuring it out alone? Join Wisconsin's top solo and small firm lawyers October 16th through the 18th at the Kalahari Resort in Wisconsin Dells for the 2025 Wisconsin Solo and Small Firm Conference. Connect with your peers, learn real strategies you can use immediately, and leave ready to grow your practice. Register today at wssfc.org.
Who better to trust when you're facing a malpractice claim than Wilmick? With their Wisconsin licensed claims attorneys and strong network of defense counsel, Wilmick was created in 1986 by Wisconsin lawyers for Wisconsin lawyers, and they continue to demonstrate their commitment to Wisconsin's legal community. Find peace of mind with Wilmick. Would you like to implement new efficiencies into your law practice but don't know where to begin? Practice 411, the State Bar of Wisconsin's Law Office Management Assistance Program, is the place to start. Don't wait. Contact Practice 411 today for a complimentary and confidential consultation at 1-800-957-4670. Thank you. And now back to the Bottom Up podcast.
So products liability in Wisconsin are who's the primary audience for this book? Are there a lot of attorneys who do this kind of work here in Wisconsin?
I would say there are not a lot.
Yeah.
I think that any firm that handles a personal injury case could theoretically do a products liability case and would at least be aware of their existence. So I think that, and I think there are more defense lawyers in Wisconsin that will take on products liability cases. I would say a lot of the insurance defense firms have lawyers with experience in that, and a lot of the bigger firms like Quarles and Brady, for example, that have litigation departments, they'll do some products liability work. A lot of the time, we're representing plaintiffs, so a lot of the times on these cases we'll see national counsel and a local counsel. So I would say there's a relatively large group of firms that are capable of doing it. There's probably a smaller group of plaintiffs firms that do it with any regularity. And I think there's a couple reasons for that. But let me tell you that first. So the book is designed to be neutral. Mm-hmm. I hope it was. So it's designed to just sort of be a neutral, here's the law, here are the issues. I tried very hard not to take sides one way or the other, or when there was an issue that maybe is unresolved, which there are a lot of, I tried to sort of just call that out rather than say,
this is how it should be.
This is how I think the court should rule.
Right.
Because obviously I have my opinion.
Yeah.
So I think the book, I hope that it's helpful to folks on all sides. It's not just it's not intended to be a plaintiff-oriented book. It's intended to be a legal reference for either side. But for example, for plaintiffs' lawyers or lawyers that may be solo practitioners, smaller firms that do some personal injury work that are thinking about taking on a products liability case, I would offer a couple of cautions. So one, the cases tend to be extraordinarily expensive. So a lot of the time, the issue is a improper design or negligent design or a defective design. And what you need to do essentially is reverse engineer the product to figure out what was the issue and then redesign the product. A lot of times, or hopefully that's a design that already exists on the market, like from a competitor or from one of the manufacturer's other similar products. But if it's not, you may have to design and create the product yourself. There's, a lot of time there's testing to be done to call out the design defect or to show that the alternative design works to prevent that defect. Mm-hmm. And so that tends to be a significant outlay of cost to engineers to figure that out. It's extraordinarily rare to have a products liability case where your costs would not be in the six-figure range. And if you're representing plaintiffs like we do, most of the time the firm is outlaying that cost.
Yeah.
And the firm is taking on the cost risk. And so if you're not doing it on sort of a semi-regular basis, it's hard to do that. Mm-hmm. And in addition, just figuring out, what kind of a defect might this be, how to retain the experts, where to look for someone that can help you to examine the potential failure of the product, taking the depositions, getting depositions of the defense experts that have been deposed previously to prepare yourself, sifting through the mountain of these cases involve e-discovery, so there's just mountains of documents. We had a recent case where there was 500,000 documents produced.
Oh my gosh.
So sifting through all that information to find what's relevant and to decipher the engineering parlance, it takes some factual expertise. Mm-hmm. And then there's some legal complexity to it. The legal complexity is the easier thing to figure out, but the factual complexity can be intense. So I would say, if a lawyer out there that doesn't regularly do this kind of work comes across a potentially good products case, bring on a referring counsel or a co-counsel and either refer it out, or if you want to learn how to do it, it would be good for you to do it, a couple of times with someone that has experience, so you can understand the level of detail, the cost before you get in over your head. And so that's my advice about that. But it can be done, and I think it's very helpful for anyone that does personal injury work to at least generally be aware of what are these cases, what form can they take, generally what is the law like, which hopefully the book is helpful to them in that.
Well, it's that's great advice. The book is going to be a fantastic resource for State Bar members. And again, Jesse, thanks for sitting in with us and telling us about it. Samantha Cherney, thanks for joining us.
Thank you, Joe Forward.
And we'll catch you next time. All right, thanks.
Thanks a lot, guys.
Thanks, Jesse.
Thanks for listening to our podcast. If you have a topic you'd like us to explore, let us know. I'm your host, Emilio Villagale, and we'll catch you next time.